Good morning, Your Honors. May it please the Court. My name is Melissa Giassi. I'm here on behalf of Mrs. Carrie Chen, who's seated at the council table with me. If it would please the Court, I'd like to reserve 5 minutes for rebuttal. This is one of the very few, if not only, cases that I will get to stand before this Court and argue essentially that this is not fair and that there's something this Court can and should do about it. This Court, as an appellate court, faces numerous cases where you're tied by a standard of review, or you're tied by arguments that weren't preserved below, or you're simply, not given the opportunity to fashion relief, but given the as-applied challenge to the statute that we've raised in the briefs, we're asking this Court to make this situation fair for my client.
I know the landscape has changed drastically in the past 8 to 10 years, but are any of the cases applicable in a retroactively? I mean, basically, that's the position.
Sure, absolutely. I think.
That has held that.
I'm sorry?
The controlling cases that you rely on apply retroactively.
Yes, Your Honor. I think that there's multiple cases cited in our briefs that stand for the proposition that a fundamental right that has been deprived, retroactive relief, is and should be available.
But is it retroactivity to the legal status of marriage? I think that's true, correct?
It is true, and it has been true.
But none of them address retroactivity as to a qualified retirement plan in the state.
Well, the two IRS guidelines that were essentially the bedrock of our argument do certainly provide that retroactive relief should be given.
Which one?
I'd
like to read it that way, but I don't see it reading that way. Which
you don't
one?
see the two IRS
2014-19?
Mm-hmm. I mean, are you saying to the extent that she elected the investment plan and not the pension plan, so because it's applied neutrally to heterosexual couples?
Well, it says that qualified retirement plan operations must reflect the outcome of Windsor as of June 26, 2013. I mean, she opted for the pension plan in September 2013. So, how's that retroactive?
Well, but it doesn't limit it just as to the date of Windsor, and to the extent that the court
says as of June. We have to read the law.
Sure.
I understand that. I appreciate this issue. I really
yes.
do. But we have to read the law as it's written.
Okay, but those two guidelines, and maybe that was the specific guideline released from the IRS, but I don't think that takes us out of the long history of jurisprudence where when individuals over the years have been deprived of what is later recognized.
You've just argued to me that this is dispositive and this is authoritative. Now you're just telling me it's a guideline. So, I mean, which is it? Well,
it's a guideline, but I think that both of my answers stand. The guideline was released by the IRS, and that it is, I think it's titled guideline, but I don't think that removes us from the fact that our jurisprudence now on the federal level and on the state level provides for retroactive relief when a fundamental right has been denied.
Well, do you have any case law that reflects to this issue? Because this guideline seems to be the only one that makes express reference to a retirement plan. Is there anything else?
Not that was available as of the time of the filing of the reply brief, but you have to recognize that Mrs. Chen was probably one of the first individuals to initiate a proceeding like this, and I don't think that the fundamental cases or the retroactive relief for fundamental rights is limited to just a retirement plan and a guideline provided by the IRS. I don't think that there's a limitation of any sort provided, going back to, cases involving the civil rights movement, cases involving, individuals who were previously not allowed to marry outside of their race. I don't think that there's limitations. I think that the progression of this case, illustrates that there's uncertainty on the administrative level. There's uncertainty within the federal system, but when I got involved with this case and with helping Mrs. Chen, we had several conversations about different routes that she could take, and this is what she wanted to focus on. So, had she, gone the EEOC route and filed a lawsuit against her employer, which she did not want to do, I don't think that IRS guideline would limit, any sort of retroactive relief that she could have been entitled to, given.
The fundamental right is the right to be able to marry whomever you wish.
Correct.
Is your ability to choose a pension plan as opposed to the IRA type thing?
Mm-hmm.
Is that a fundamental right?
No, but it is a direct result of the
discrimination.
Correct.
Against, okay.
Correct.
That's your position. Okay.
My opponent has cleverly pointed out that the investment plan that she did ultimately elect does apply to same-sex couples and heterosexual couples the same way, but I think that misses the point. I think that the fact that my client very carefully and very intelligently made an election, the only election she had to provide any sort of death benefits to her wife, should something happen to Mrs. Chen, who is the sole breadwinner for the family, that very clearly flows from her testimony. It very clearly flows.
But the retirement plan scheme was the same then as it is now, and the buy-in was expressly in the pension plan portion of the retirement plan when she elected that. Mm-hmm. She knew that if she elected that and then got married, and in her hopes that it became legalized, she'd have to do the buy-in.
But I think that's
it's not like she's not on notice.
I agree with that, but it's
you're
not like she had a
us,
crystal ball, Judge
I understand
Lee.
that, but if you're asking us to carve out an exception in a federal guideline that doesn't exist,
that's not what I'm.
When do the exceptions stop?
Well, I can't answer.
Who do we exclude and who do we include, is what I'm saying. So.
Well, I can answer that in two different ways. So the federal guideline was inserted into this because the original position of the agency was that they couldn't do anything about it. So she presented those guidelines, and then their position became, well, you didn't have a crystal ball, so you weren't legally married when you had to make that election. So while the pension plan, the investment plan, and the buy-in, sure, they were all essentially the same as they are now, I don't understand how this court does not see that my client, whose marriage would not be legally recognized by Florida for 5 more years, had the same opportunity, had the same rights as someone who was in a heterosexual marriage.
One of the things that I've sort of tried to put my head in her head and think about the decisions she made and why she made them. Among the things that I'm troubled by is that she waited 3 full years after she legally could change to change. And so it caught, well, her marriage became legal in 2013. She made the change in 2016.
Her marriage did not become legal in Florida until 2016, late 2015.
Okay, good point. The other issue,
and that's her, and she does testify, and I'm sure at the hearing about the reason that she incurred the cost to go to Massachusetts once it became clear there was a benefit on the federal level. And I think she acted quite expeditiously after the statute defining spouses, either a man or woman, to start this process.
The other concern I have is that the basis of her decision to go into the investment plan at that time, because given her marital status and the legal status of that marriage, in her view, that was the best thing to do for her family.
Correct.
To protect them.
It was the only right she had to protect her family.
But there's a lot of people that go into the investment plan for exactly that same motivation, but for different reasons. First of all, the investment plan is the only plan you have that if once the beneficiaries die, there's something left to pass on to your heirs. Where the pension plan dies, immediately, it's gone.
That's not true.
Well, that is true.
No, Your Honor, and we discussed that in our,
There is that one option where you get 10 years.
that's one option.
Right.
So there's 4 options. One of them, you get the life and 10-year certain provides slightly reduced benefits but pays to the spouse if the,
Well, you misunderstood what I
Okay.
said then. I said when the beneficiaries die.
Okay.
Either if there's
Okay.
two, the last surviving beneficiary, when they die, there's nothing left on the table.
okay,
In the investment plan, there can be plenty left on the table. It could be all left on the table.
okay,
Okay, there's a vesting schedule also that goes with the investment plan.
Right.
There's 1 year versus, now it's 8, but in her time it was 6.
mhm,
So there are a lot of family reasons
mhm,
why a lot of people go into the investment plan. You know, another reason a lot of people go into the investment plan?
Why?
They don't trust the government. They basically say 10 years out, those clowns could come back and say, you're only getting 50 cents on the dollar, sorry. Can't do that with the investment plan, it's all your money.
and I
There are a
understand that.
lot of good family reasons
There are,
to pick the investment plan.
and I understand that, but
She
I,
may very well have been motivated to do that at the time she made that decision, but what happened,
but the,
when
her
she went to
testimony,
work in
mhm,
2010, guess what happened to the stock market?
what?
Wasn't looking too good. If she were in the investment plan today, she'd probably be really happy with it.
These are, and you bring up a good point. At one point during the agency proceedings, we asked for the case to be converted to a formal hearing where all of this maybe could have been fleshed out. But I will point out to Your Honor that her testimony was not any of that. Her testimony was, I had no other option. I'm the sole breadwinner. And so, there's a variety of family structures. There's a variety of families where both spouses or both, committed, couples are breadwinners, and she was the breadwinner, is the breadwinner. So, her testimony, her genuine testimony was, I felt like I had no other options because, my wife stays at home with our 3 children, and if something were to happen to me, she would be left with nothing.
But candidly, all that hearing officer had was her testimony against all the other things I've just explained to you.
Well, I don't think that any of all of this, all of the valid, speculative circumstances that you've mentioned aren't part of the record. But again, that goes back to the point that we went so far as to ask to be converted to a formal hearing. The hearing officer denied it. We filed a petition for review with this court, and this court said, you've preserved that, come back.
But isn't this really a legal argument?
I'm sorry?
I mean, if you had a formal hearing, would it really change the legal argument that you're making now? Because I think that the recommended order probably supports my position at this point. You can correct me if I'm wrong, but we understand the facts. We understand her reasons, and her reasons make sense. I don't know that there's anything else factually that needs to be said. And the hearing officer had said, it was of his or her opinion there was no barrier to the respondent amending the plan, which meant it's within their sole discretion. But there's no law requiring them to. So it was an equitable recommendation. Would you agree?
I think that her recommendation, which really isn't in play because the agency...
Yeah, but when you get to the point about your formal hearing
Sure,
request,
no.
because I don't know that it would have made a difference.
Well, we don't know that.
But
And
would your argument be any different?
my argument would be...
Your argument is fundamental fairness.
a fundamental right that has been deprived.
And I think this court, all 3 of us, really appreciate that. I don't know if there's any other facts that would really enhance fundamental fairness. It means what it says.
Sure.
So when we look at that, we need to look at what we're guided by.
Sure,
And all we have is this IRS.
Well, I disagree
provision.
respectfully, Your Honor. I think what we have is decades of jurisprudence that give courts and administrative agencies flexibility when it comes to making someone whole whose fundamental right has been deprived. And one of the one of the authorities that we filed in connection with the brief, dealt with this issue. How do you backdate marriage? Should you backdate marriage? And one of the, the testimony before the informal hearing officer was, that Mrs. Chen and her wife traveled to Tennessee in 2001. These are good facts. This isn't opening the floodgates for, a lot of citizens coming and demanding the same kind of relief. My client went through a formal name change petition in 2010, even before she was faced with an election to either take the pension plan or go with the investment plan. She's been involved in litigation to have both her and her wife's names on both of their children, on all of their children's birth certificates. My understanding of the relief provided to individuals following the recognition of a new fundamental right, which is exactly what happened when Obergefell was released, is that the rules are bent a little. And I think that, at a minimum, she should have had the opportunity to present testimony and all of the evidence and ask for her marriage to be recognized.
Kelsey, excuse me, you're up to 16 minutes.
Thank you. I'll save the rest of my time for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court, I am Ruth Ann Smith, representing the appellee, the State Board of Administration. What appellant has been arguing is that the SBA should be responsible for any adverse impact that Florida's Defense of Marriage Act, set forth in Section 741.212, had on her retirement plan choice. But the fact is, the SBA was not impacted by Florida's Defense of Marriage Act. Under the investment plan, as you pointed out, anyone can be a beneficiary. It does not have to be a spouse. It can be a relative, a friend, a pet. So Florida DOMA really didn't have any impact on it. And the case, the U.S. Supreme Court case, Ex parte Young versus United States, said that a state official can be liable for constitutional violations if that officer enforced an unconstitutional law. But with respect to the appellant, the SBA never had to enforce Florida DOMA against her. As I said, anybody could be a beneficiary, so it was irrelevant for her purposes. Now
I understand the argument, but doesn't it miss the point? I know there's no discrimination in the operation of the investment plan as to who can be a beneficiary, but my understanding is that there were two options, and because of the family situation, the only option that was available was the investment plan because the pension plan was foreclosed.
It wasn't foreclosed. She could have joined the pension plan. Several of the plaintiffs in the Brenner case were members of the pension plan and had been for a long time. And they decided after U.S. versus Windsor that they would like to name their joint annuitant. The joint annuitant doesn't come into play till retirement. In appellant's case, she was about 32 when she joined the Florida retirement system. She wouldn't have been eligible to get a benefit till normal retirement age, which would have been 30 years, or age 62, which actually would have been the same in her case. So
The difficulty with this is to get in the minds of somebody who's making a decision like this, because frankly, there are some married people who are in the pension plan. When it comes time to pick an option, they pick for their life only. For
Sure.
whatever investment
Absolutely.
decisions they want to make. Some of them do it, and then they go buy life insurance on themselves.
Absolutely.
For their spouse to be able to. So that's the difficulty with this. There's lots of ingredients that go into this decision, and it's hard to really sort of know exactly what's in a person's mind totally when it happens. The other interesting thing is that when she elected to make the change in 2016, stock market wasn't doing so well. She got
Correct.
$11,000 shortfall. If she'd have made it in 2018, I didn't do the math, but somebody could do the math, she probably wouldn't have paid anything.
Or she may have had a balance.
And then the question becomes, is the state supposed to be the underwriter of everybody's decisions every time that they make a decision like this?
No, sir, they are not.
But in this case, even though it's an informal hearing, the only testimony, and I don't think anybody found it to be incredible, was that the pension, the investment plan was chosen for the specific reason of providing a benefit for spouse. There's no dispute about what was in her head.
No, and I'm not arguing that, as I said, but that situation wouldn't have arisen until she retired. The investment plan's not a life insurance policy. She couldn't use it in the current time if something happened to her. She would have to wait till she reached normal retirement age, or about 30 years after she joined. The appellant did file before this very court a petition for a review of non-final agency action. And in that, she alleged that if Mrs. Chen's legal marriage was deemed to have occurred on September 27th, 2013, which is the date that Mrs. Chen and her spouse were married in Massachusetts, then that fact would preclude the exact retroactive relief that she was seeking in the underlying proceeding. The record lacks any evidence that appellant ever tried to have her, what she called a marriage-type relationship, which occurred in Tennessee in 2001, declared a legal marriage for purposes of the U.S. v. Windsor decision. She instead chose to go to Massachusetts about 3 months after the Windsor decision and entered into a legal marriage there so she could take the benefits under federal tax law. She never tried to say, well, the arrangement that I entered into in Tennessee was a legal marriage for purposes of federal law or state law. And in fact, the Treasury regulations, which were enacted to define husband, wife, and spouse, said specifically that these individuals were deemed to be, were individuals that were lawfully deemed to be married. And anything short of a legal marriage would not pass muster for IRS purposes. And the IRS noted there was reason for that because many people enter into arrangements that are something short of a legal marriage. For example, a person that may have had been married before and was receiving retirement benefits from his or her spouse, and the spouse died and then wants to go into a new marriage. Well, if he or she was married again, that would foreclose any further benefits under the former spouse's plan. So people might want to enter into a commitment ceremony so that they feel they're committed to each other, but it would be something less than what would be recognized as a legal marriage. I believe the IRS noted also people that may be receiving Social Security benefits from a deceased spouse would have the same situation if they got remarried. So there were certainly reasons the IRS decided not to deem anything short of a legal marriage a legal marriage. Are there any further questions, Your Honors?
Thank you very much.
Thank you, sir.
Ms. Johnson.
The as-applied challenge that we brought before this court, keeping in mind that the 741, 42, whichever Brenner declared void, it's void ab initio, I think that gives this court the route to go back to the as-applied challenges that we've raised in the brief. First, the statute requiring all retirement participants to either elect the investment plan or be defaulted into the pension plan, as applied to Mrs. Chen, given the void ab initio status of the 724, the statute that said a man and a woman don't qualify, any marriage other than one between a man and a woman don't qualify. I think that this court can craft and should craft that relief. I think that this is, one of several cases of the type in the pipeline here and statewide. I know of several that are pending before the 4th District Court of Appeal. I know several in the 3rd, and each one is going to be fact-specific, and that is, frankly, historically, how things have been handled when our Supreme Court has recognized a fundamental right. Retroactive relief, I think that this court has an enormous amount of flexibility, whether it wants to do so through recognizing that as applied to Mrs. Chen after the statute was void, that her relief should be granted under that avenue. I think that this court could reverse the case back for a formal hearing, which frankly, the fact that she was not granted a formal hearing, I think has due process implications, and I think that this court could allow, within the context of that formal hearing, for the evidence to be presented that strongly supports that but for the illegal void deprivation of her fundamental right, Mrs. Chen would have been married in Florida. And I think we haven't even gotten to the part where the hearing officer did grant limited relief, and that was rejected by the agency without the requisite findings. And I do believe now, given the new standard of review, that this court does not owe deference to the agency's interpretation of the rules. And I just would like to spend the rest of my time, I know this is in my brief, but my client is here and she feels very strongly about it. I want you to hear what this case means to her in her own words. So this is how she summarized the case. Florida is the one who denied me the ability to legally marry and denied the recognition of out-of-state marriage. It is absurd that an agency of the state who structured my pension beneficiary choices with this denial, restricting me, is the same agency of the state that now requires me to have been in a legally recognized marriage at the time of choosing my pension plan. I was denied a constitutional right to have a legally recognized marriage, and I am now required to have had it. I am not the one who should be required to retroactively right this wrong. If the agency of the state requires that I should have been in a legally recognized marriage, then the same agency of the state should examine my case and backdate my marriage. If I wasn't suffering from constitutional discrimination in 2010 or 2011 or even in 2001, I would have had a legally recognized marriage at that time. I cannot be denied something and then been told I am now required to have had it. So I thank this court for the time today.
Thank you, Ms. Johnson. Thank you both.
Thank you.
That concludes our docket for this morning. We are adjourned.